Welcome. My name is Ruben Rojas. I'm an attorney in California, and I'm currently reviewing some cases that I also viewed while I was in law school. If you're new to the channel, you should really take a look at my previous videos. The first one being regarding torts, the second regarding criminal law, the third one regarding constitutional law, the uh, the fourth regarding contract law, and the fifth regarding civil procedure. Each one is only covering one case, but it gives you a bit of a taste of what each of them is about. Now, today's case is going to be about property law. Now, property isn't always physical things necessarily, not at least not in the movable sense. That's personal property. Uh, Property also includes real estate. And a lot of what you'd see in this course is regarding, in fact, real estate. So you'll see a lot of law regarding land. Matter of fact, if my memory serves me correctly, that's a good, like at least half of what the course is about is like land and real estate law. So if that's ever interested you, then you're in the right place. Okay. As you know, if you've seen my previous videos, my style of teaching is a bit chaotic, and it's chaotic on purpose. It's not simply because I just didn't feel like preparing. It's frankly because the Socratic method, which is a method of teaching that Socrates has been teaching or taught in the past, back in ancient Greece, is the method that is used for teaching law in law schools. And Socrates taught by having the student think for themselves. He didn't ever really give a straight answer on anything. His whole point was that people need to come to their own conclusions. And the easiest way to do that is to create some chaos, controlled chaos specifically, and allow the student to come to their own conclusions by navigating that chaos. And Socrates would essentially be a guide. Now, when you're in law school, you are navigating these legal waters, but you do need some sort of a baseline foundation. Like you really need to know, generally speaking, like where is this going? And unless you've seen somebody go through it before, it's really difficult to figure out what it is that you're supposed to be doing. So that's what I'm doing. I'm going over some cases that you would definitely see in the first year of law school. Matter of fact, most of these are the exact same cases that I saw while I was in law school myself, particularly in the first year. Now, as I mentioned in my previous videos, there is plenty of reason to still want to see these to get a foundation of law, even if you have no intention of ever attending law school. Most of that is because if you have no foundation, it is really, really difficult to communicate with a lawyer about your wants and needs when a legal situation does come up. For another, if you have no foundation, it is really difficult to identify when and where it is appropriate to get a lawyer. Meaning, something might happen in your life and you might not even realize that this is something that you need a lawyer for. And in that effect, you may end up missing out on compensation that you're entitled to, or your rights may be violated in a fashion that you don't even know that you should be protected against. In the sense of specifically criminal law, you could be foregoing certain rights uh, and defenses if you were ever accused of a crime. Goodness forbid. But if you have some sort of foundation, you can mitigate a lot of those risks before they even occur. And the same thing occurs in your own personal life. If you are working, no matter if you're working for someone else or if you run your own business, if you run your own business especially, you really need to know a good foundation of law because you are subject to law and you have, especially if you have employees. Um, but even if you don't, you're still going to be engaged in contracts and You're still going to have to understand taxation. You're going to need to understand how to what makes a deal and what turns it into a contract. Okay, so as I mentioned in my previous videos, these videos are going to be unscripted. I don't even know what I'm going to say until after I've already said it, frankly. And a good piece of that is because I want you to see what it is that I'm thinking as I'm going through a case. See, now it's been years since I was in my first year of law school, and I've had time to think it over and to have the sort of method to the madness, that guidepost in how to navigate those chaotic waters. So reviewing them again many years later, where I haven't reviewed these cases in depth, is a lot like what you should probably be thinking if you were reading these cases for yourself. Now, again, the reason why this channel is different and structured differently from what you would see in other legal channels where they just tell you, hey, look at this case. Like, in this case, they said that, you should be quiet when you're around the police. Don't tell them anything. The reason why this is not structured like that is because it's a lot like giving a person a fish. Now, there's a time to give a person a fish, and there's a time to teach someone how to fish. True. If you're familiar with that phrase of give a man a fish, feed him for a day, teach him how to fish, feed him for a lifetime. The trouble is that law school teaches you how to fish, but you might not know how to. You might need a fish right now, frankly. So this is a bit of a stopgap. It's a little bit of an in-between. It's showing you how to fish and then giving you the fish that I caught so that you can still have something to eat for today until you learn how to fish for yourself. If that makes any sense. Okay. Here we go. So we're just going to jump into this. If you haven't already seen the other videos, like I said, I strongly recommend looking at those first. If you are in law school, by the way, and this is your first video that you've seen, I strongly recommend looking at commercial summaries for cases. Quimby is really good. I used them myself when I was in law school, and I also used them when I was preparing for the bar. So, I feel like they were really good. They create summaries that are both written as well as videos, so it makes it very easy. Like I said, you need a little more, I think, personally. It's much easier to understand the material if you have that little bit extra. But it's a really good place to start. So take a good look at them. All right. Here we go. It's time to lower up, people. Let's go. All right. Okay, so this is Justia. I believe that they may also do some summaries, but I'm not sure. So you can go ahead and take a look at that. The reason, by the way, why I'm using Justia and not like Westlaw or LexisNexis is frankly because Justia is available to everyone. Like it's an unpaid service. If you were to Google Johnson and Graham versus McIntosh, you would be able to click on the link and you would be able to read this case for yourself. Whereas another website like Westlaw or LexisNexis, like you have to have a subscription and they're not cheap. So this is a good way to for people to be able to access the same material. Okay, so yeah, you can literally jump on Google and look this up. No problem. Here we go. So whenever you're looking at these cases, as I mentioned in the other videos, you should always look to see where it's been argued and when. This is like property law is really old. It's one of the oldest. It's one of the oldest like forms of law that you study in law school. we figured out a long time ago, I guess, that we want people to have certain rights when it comes to property, and people have been fighting over stuff for a long time. So we've kind of, I don't want to say we got it nailed down by now, but you know, some of these cases they haven't moved, and we've been teaching them the same way since 1823. You know, so here we are, many years later, still going over the same stuff. Now, this was argued in the U.S. Supreme Court. The reason why you should be looking at like where it's happened and when is because it tells you about the environment of which was used to come up with the reasoning. It's like if you're familiar with the nature versus nurture disputes, where if I remember the old experiments and thought experiments were regarding if you can determine someone's success based on their genetics or based on their upbringing. So far as I know, the experiments have actually concluded, and they just basically came to the conclusion that neither alone is enough to make like a strong prediction. It's a combination of the two. So that's why we look at when and where something occurred, because those factors, those environmental factors, in the sort of like nurture part of the equation, really do influence the thinking and the sorts of events that that came from each case. So 1823 was a very different time and a very different place in both the U.S. and the world at large. And we said things differently and we thought very differently. So some of these things may be updated at this point. They may be even completely different. Or for that matter, if we were to visit them today, if we were to have this same situation today, maybe the ruling would not be the same. So it's important to look at that, because knowing the circumstances and the events that were going on at the time can kind of give us an indication of, is this a type of case that if a similar event was to occur today could be overturned? Like, can the reasoning, can alternative reasoning be used to overturn a case? And I mean, as far as I can tell, highly experienced lawyers, that's one of the things that they look at. Okay, here we go. Let's just jump into it. So under most with most cases in law school, I normally recommend that you go look at the opinion first before you look at like the facts. And in the past 3 videos now that I've looked at, the opinion was like really, really short. And the opinion, by the way, is where the court like says, oh yeah, this is what we came to a result. And normally there's like a facts and opinion section, and the facts on most cases are relatively long because they're like giving you the circumstance and all the little micro situation and things that were considered are usually embedded in the facts. And then the opinion is the law and the reasoning that came out of it. Usually. That seems to be different with these foundational cases in the beginning of like 1L courses. I mean, like I said, this one, and again, it's because it's an old case and that's how they just wrote back then. The facts are really short, and then the opinions are really long. So, yeah, here we go. Now, like I said, I don't remember what this case is about, so it's gonna be interesting. I'm gonna skip this syllabus because I normally talk about stuff that is like, I don't want to say it's irrelevant because it's not irrelevant, but it's stuff that gets covered later and not what you would normally see in a case book. Where'd you go, opinions? Did I? Okay. All right. Normally, by the way, with these opinions, it literally says, is this under? Yeah, okay. It normally just says the name of the judge or justice. Um, and that's how you know that it's starting. The opinion is starting. Okay, it looks like they're still going to give us some facts here. So I'm just going to read them anyways. Okay. So this is originally in the court of Illinois. Yeah, okay. A title to lands under grants to private individuals made by indigenous tribes or nations northwest of the river Ohio in 1773 and 1775 cannot be recognized in the courts of the United States. Discovery, the original foundations of title to land on the American continent, as between the different European nations by whom conquests and settlements were made here. Recognition of the same principle in wars, negotiations, and treaties between the different European powers. Adoption of the same principles by the United States. So this is, okay, literally actually a syllabus. I am so sorry. Let's skip forward. To me, these case books can be kind of chaotic too, and like the way that they were written. Especially, like I said, older cases. You know, they're just so different. The way that the writing style is, you know, it's still proper. Clearly, like, you know, judges are very well educated. They're by no means, they're not dumb by any means. Okay, so this is actually where the opinion begins. Okay, this is what I'm talking about. Like, you know, it's written very differently, and this is where you want to, normally where you want to start. Okay, Mr. Chief Justice Marshall delivered the opinion of the court. The plaintiff in this cause claim the land in their declaration mentioned under two grants proportioned to be made, the first in 1773 and the last in 1775 by the chiefs of certain Indian tribes constituting the Illinois and the Pinkishaw nations. Man, I know that I butchered that name. If you hear this and you're from this tribe, oof, I'm sorry that I butchered it so bad, okay? And the question is whether this title can be recognized in the courts of the United States. The facts as stated in the case agreed, showing the authority of the chiefs who executed this conveyance so far as it could be given by their own people, and likewise showed that the particular tribes for whom these chiefs acted were in rightful possession of the land they sold. Okay, so this land is not like stolen or anything. It did belong to them, right? Meaning they were capable of selling it. The inquiry, therefore, is in a great measure confined to the power of Indians to give, of the private individuals to receive a title which can be sustained in the courts of this country. As a right of society to prescribe those rules which property may be acquired and preserved is not and cannot be drawn into question, as a title to land especially is and must be admitted to depend entirely on the law of the nation which they lie. Okay, so this is talking about the jurisdiction that applies whenever property is the is the nature of the controversy. So if it is in one state, let's say it's state of California, right? And the lawsuit is being originated in like Nevada, let's see, then where the land itself is located, where the land itself is located is relevant, like as far as jurisdiction and which rules are going to be applied. Okay. It will be necessary in pursuing this inquiry to examine not singly those principles of abstract justice which the Creator of all things has impressed on the mind of his creature man, and which are admitted to regulate in a great degree of rights of civilized nations, whose perfect independence is acknowledged, but those principles also which our own government has adopted in the particular case and given us the rule of our decision. Okay, this is what I'm talking about, like the time, right? Like they're talking about God and God creating the world and God allowing mankind to have a mind of their own and being permitted to regulate a great degree of rights of civilized nations. So man's ability to rule over itself, right? And for the time, it makes sense that we're talking about a lot about God. Now, much of law, I think you will discover later, if not already, much of law is based on religion. And if you look at law in different nations, like around the world, if you understand their religion, you understand their frame of mind. And if you understand their frame of mind, then you understand how they create laws for that region. Like laws in the US look different from laws in Japan. But like the majority of the US is like Christian for the most part, or at least it was when it was founded. And the majority of Japan is Buddhist, if I remember. So their laws look very different. Granted, whenever World War II ended, we imposed different different laws over there, and so their culture has even changed as a result. So their culture changing affected the laws, and the laws changing affected their culture. And same thing with even with us, with the U.S. We had wars with Native Americans in the U.S., and then we imposed different laws, and their culture has changed, and their legal system has changed. So these are things to be aware of. Okay. On discovery of this immense continent, the great nations of Europe were eager to appropriate to themselves so much of it as they could, respectively, acquire. Its vast extent offered an ample field to the ambition and enterprise of all, and the character and religion of its inhabitants afforded an apology for considering them as a people over whom the superior genius of Europe might claim ascendancy. So yeah, I mean, I actually didn't realize that they were going to talk about religion here. I kind of, like I said, I haven't reread this, so I'm almost a little surprised that they talked about it back in 1823 of all times. Because um, back then, at least it doesn't seem to me like they were really hyper aware of how religion like impacts law. But I mean, that's what I mean. That's basically what they're talking about here. And you really got to pay attention to language, like how they're wording things. I mean, look at this. This justice that wrote this, like considering them as a people over whom superior genius of Europe might claim ascendancy. This is still 1823, so the U.S. is still like really angry with Europe. We rebelled. We were angry teenagers, right? We rebelled against our parents. Big Daddy Europe, and we're still like upset with them at this point in 1823, after the Revolutionary War. Like I guess we hadn't really calmed down by 1823. So yeah, and it also even makes you wonder. I don't know the military history of this justice, but like maybe they're old enough to be in war. Maybe they were, maybe they were a fighter in the Revolutionary War. Who knows? I'd have to look into it, but it's things to consider. Like these sorts of things. This is my point. Like these sorts of things, like the mental environment of a person affects how they're going to rule in a case. We'd like to think that it's all just logic and a numerical decision of like 1 + 2 = 3, but not always. And just like 1 + 1 can mean 2, can equal 2. It can also equal to 0 if we're going on binary. Which system are we using? Which is again part of the point here. Okay. These potentates, I don't know what this means. What does this mean? Potentates. A monarch or ruler. Okay. Yeah. These potentates of the old world found no difficulty in convincing themselves that they made ample compensation to the inhabitants of the new by bestowing on them civilization and Christianity in exchange for unlimited independence. Oh, yeah, okay. Man, this justice was not playing around. I'm actually genuinely surprised. Like I said, I've read this case before, but even like looking at it now that I've been through law school, passed the bar, done all that, I'm actually really surprised that they talked about this in 1823, like at a time when, frankly, like being anything other than Christian was probably not very well accepted. Although we have freedom of religion as as a as an amendment embedded in the Constitution, the First Amendment at that, right? Like, so I'm almost surprised. I'm not completely surprised. Like, clearly they're a big proponent for the Constitution, but I'm almost surprised that they brought this up. Anyway, okay. But as they were all in pursuit of nearly the same object, it was necessary, in order to avoid conflicting settlements and consequent war with each other, to establish a principle which all should acknowledge as the law by which the right of acquisition, which they all asserted should be regulated as between themselves. This principle was that discovery gave title to the government by whose subjects or by whose authority it was made against all other European governments, and title might be consummated by possession. Okay, so whoever finds something first, whoever finds something first gets it. That's the discoverer wins. This principle was to discover. This principle was that discovery gave title. That's it right here. Discovery gives title to the government by whose subject or by whose authority it was made against all other European governments. Boom, right there. By whose title might be consummated by possession. Yeah, okay. The exclusion of all other Europeans necessarily gave to the nation making the discovery the sole right of acquiring the soul from the natives and establishing settlements upon it. It was a right to which no Europeans could interfere. It was a right which all asserted for themselves, and to the ascension by which all others assented, meaning disagreed. I'm sorry, agreed, not disagreed. Dissented would be disagreed. Assented is to agree. Okay. Those relations which were to exist between the discovery and the natives were to be regulated by themselves. The rights thus acquired being exclusive, and no other power could interpose between them. In the establishment of these nations, the rights of the original inhabitants were in no instance entirely disregarded, but were necessarily to considerable extent impaired. Okay. All right. So they're saying they still had rights, but they were, I don't want to say, I don't, yeah. They were well, they were impaired. They were hurt. Like they didn't have the full capacity of their rights, even though they still technically had them. Yeah, they weren't able to use them to their full capacity. They were admitted to be the rightful occupants of the soil, with a legal as well as a just claim to retain possession of it, and to use it according to their own discretion. But the rights to compete sovereignty as independent nations were necessarily diminished, and they're empowered to dispose of the soil at their own will to whomever they pleased was denied by the original fundamental principle that discovery gave exclusive title to those who made it. Okay. And you will find later that like owning something in terms of law means being able to like pass it on and give it to somebody else. While the different nations of Europe respected the rights of the natives as occupants, they asserted the ultimate dominion to be in themselves and claimed and exercised as a consequence of this ultimate dominion a power to grant the soil while yet in possession of the natives. These grants these grants have been understood by all to convey a title to the grantees, subject only to the Indian right of occupancy. The history of America, from its discovery to its present day, proves, we think, the universal recognition of these principles. Spain did not rest her title solely on the grant of the Pope. Her discussions respecting boundary with France, with Great Britain, and with the United States all show that she placed in on the rights given by discovery. Portugal sustained her claim to the Brazils by the same title. France also founded her title to the vast territories she claimed in America on discovery. However, conciliatory, I'm relatively certain this means okay, yeah, intended or likely to placate or pacify. Okay, yeah, okay, all right. However conciliatory her conduct to the natives may have been, she still asserted her right of dominion over a great extent of country not actually settled by Frenchmen, and her exclusive right to acquire and dispose of the soil which remained in the occupation of Indians. Her monarch claimed all Canada and Acadie as colonies of France at the time when the French population was very inconsiderable and the Indians. Yeah, okay, very. I was like, did I read that right? Yes, I did. Okay, very inconsiderable, and the Indians occupied almost the whole country. He also claimed Louisiana, comprehending the immense territories watered down by the Mississippi and the rivers which empty into it by title of discovery. The letters patent granted to the Sieur de Monts, Sieur de Monts, Sieur de Monts. I don't know how to pronounce that. I'm not French. Is this French? I think this is French, but I'm not sure. Sieur de Monts in 1603 constituted him lieutenant general and the representative of the king in Acadie, which is described as as stretching from the 40th to the 46th degree of north latitude, with the authority extending to the power of the French over the country and its inhabitants, to give laws to the people and to treat with the natives and enforce the observance of treaties, and to parcel out and give title to lands according to his own judgment. Okay, this, by the way, I spoke in a previous video talking about like nobody in the US really owns land besides the government. This is what it means to own land. Like this is it right here, you know. The authority, boom, right here. This is what it means to actually own land. The authority to extend the power of the French over the country and its inhabitants, to give laws to the people, to treat with the meaning treaties with the people and enforce the observance of treaties, and to parcel out and give title to the lands according to its own judgment. If you cannot do that, then you don't own land. So, you know, whenever we like buy a house in the US, you're not really buying land. You're buying you're renting basically permission to plug into a system that allows you to build a house there. Yeah, that's basically it. And there's nothing wrong with that. Again, as I mentioned there, like you wouldn't really want to own, you really wouldn't actually want to own land because you'd have to create your own laws over it. You'd have to defend it like physically from attackers and other nations. You'd have to enforce the rule of law over like people who would violate it. So like criminals and stuff like that. Like and you would be essentially subject um to being able to deal with other governments. So yeah, like owning land is not all it's all that it's cracked up to be. If you were to actually own land, which, like I said here, we don't do that. Okay. Which, by the way, something that you'll see later too includes the animals that are on that land. So I think back in the day, like all the like animals and game and stuff, like they all belong to the king. Um, and it's imparted on, again, religion. I believe, and I could be very wrong on this. I believe that historically, sovereigns like monarchs, they got their authority from God. Um, so that was why like kings owned everything, because God gave them the right to, basically. And now government has taken over that. So you know, uh, I believe I believe in the U.S. it's the states. The states they're basically the replacement for a king. Yeah, yeah. So food for thought. It's just kind of one of those fun facts, I guess. It's not really like something that would impact most people, I don't think. Though I mean, there's things like water rights and stuff like that. So yeah, I guess it does impact you. It's just kind of invisible to an extent. Yeah. Okay. The states of Holland also made acquisitions in America and sustained their right to the common principle adopted by all Europe. They allege, as they were told by Smith in his History of New York, that Henry Hudson, who had sailed, as they say, under the orders of their East India Company, discovered the country from the Delaware to the Hudson, up which he sailed up to the 43rd degree to the north latitude, and his country they claimed under the title acquired by this voyage. So that's who owns the land, like which country owns this piece of land, right? The first object was commercial, as appears by the grant made to the Company of Merchants in 1614. But in 1621, the States General made, as they were told by Mr. Smith, a grant to the country to the West India Company by the name of New Netherlands, excuse me. The claim of the Dutch was always contested by the English, not because they questioned the title given by discovery, but because they insisted on being themselves the rightful claimants under that title. Their pretensions were finally decided by the sword. Okay. No one of the powers of Europe gave its full assent to the principle more unequivocally than England. The documents upon this subject are ample and complete. So early as the year 1496, her monarch granted a commission to the cabots. What's a cabot? All right, let's see if we need to do. Okay. Italian navigator and okay. So there is a John Cabot. Male given name. Oh, so I guess it is actually a person. Okay. I thought maybe it was a thing. All right. I guess not. Her monarch granted a commission to the Cabots to discover countries then unknown to the Christian people, So I guess it was actually the Italian explorers. Okay. Known then to the Christian people and to take possession of them and in the name of the King of England. 2 years afterwards, Cabot proceeded on his voyage and discovered the continent of North America, along which he sailed as far south as Virginia. To his discovery, where English trace their title. In this first effort made by the English government to acquire territory on this continent, we perceive a complete recognition of the principle which has been mentioned. The right of discovery given by this commission is confined to countries then unknown to all Christian people. And of these countries, Cabot was empowered with the possession in the name of the King of England, thus asserting a right to take possession, notwithstanding the occupancy of the natives, who were heathens, and at the same time admitting the prior title of any Christian people who may have made a previous discovery. All right, what is I'm almost afraid to look this up. What is a heathen? Is that Does that mean somebody non-religious or doesn't believe in God? Heathens generally refers to people not adhering to Christianity, Judaism, or Islam, or those adhere to a different religion. So I don't know if this is the same definition that was used back then. Let's see if Webster has something different. Old-fashioned and awfully often disparaging of or relating to people of nations who do not practice Christianity, Judaism, or Islam. So basically anyone that doesn't believe, it looks like, in God. I don't know, like, I'm not going to, say the names, but so I'm guessing like Buddhism and Hinduism were probably considered heathens based on this definition, or relating to heathens, their religions or their customs, pagans. Okay, all right. Old fashioned. Okay, it's the same. It's the same. Okay. So they're saying that Native Americans they didn't have the same religious beliefs. Okay. Thus asserting the right to take position, notwithstanding the occupancy of the natives who were heathens, which today, if we were looking at this, they would be like, religion doesn't have anything to do with whether or not you own land. But it seems like at this time that was like a factor. That was something that they looked at. And at the same time admitting the prior title of any Christian people who may have made previous discovery. Like, I don't know if this is a side note. It almost doesn't look like it has any specific operation, right? Like, at least so far. Maybe later that's gonna change. Like, maybe later they'll be like, if they weren't heathens, then this case would have come out different. I don't know. We'll see. Okay, the same principle continued to be recognized. The charter granted to Sir Humphrey Gilbert of 1578 authorities authorizes him to discover and take possession of such remote, heathen, and barbarous lands as were not actually possessed by any Christian prince or people. What does it mean to be barbarous? I mean, I assume that's like a barbarian, but like, what exactly is a barbarian? Savagely cruel or exceedingly brutal. In ancient time, a member of a community or tribe that belonged to one of the great civilizations. So, like, it literally was like, if you're not one of us, you're a barbarian. Okay, now I know. Which, I mean, they basically, if you think about it, they actually stated the same thing twice. Basically, like, if it's a barbarous land, that they were not actually possessed by a Christian population, right? Like, at least if that same definition that we saw earlier was the same definition back then, which who knows? Maybe it's changed, maybe it's not, maybe maybe it doesn't mean the same thing. It's worthy of note, but okay. Okay. This charter was afterwards renewed to Sir Walter Raleigh in nearly the same terms. By the Charter of 1606, under which the first permanent English settlement on this continent was made, James I granted to Sir Thomas Gates and others those territories in America lying in the seacoast between the 34th and 45th degrees of north latitude, of which either belonged to that monarch or were not then possessed by any other Christian prince or people. The grantees were divided into two companies at their own request. The first, or southern colony, was directed to settle between the 34th and 41st degrees of the north latitude, and the second, northern colony, between the 38th and 45th degrees. In 1609, after some expensive and not very successful attempts at settlement had been made, a new and more enlarged charter was given by the crown to the first colony, in which the king granted to the treasurer and company of adventurers of the city of London for the first colony of Virginia, in absolute property, the lands extending along the seacoast 400 miles and into the land throughout from sea to sea. The lands extended along the seacoast 400 miles and into the land from sea to sea. Okay. This charter, which was part of the special verdict in this cause, was annulled, so far as respected to the rights of the company, by the judgment of the Court of the King's Bench on a writ of quo warranto. It's Latin, so I don't know how to pronounce it. Warranto. But the whole effect allowed to this judgment was to revest in the crown the powers of government and the title to the lands within its limits. At the solicitation of those who held under the grant to the second or northern colony, a new and more enlarged charter was granted to the Duke of Lennox and others in 1620 who were denominated by the Plymouth Company. Conveying to them in absolute property all the lands between the 40th and 48th degree of north latitude. Under this patent, New England has been in a great measure settled. Okay, so this is New England. The company conveyed to Henry Roswell and others in 1627 that territory which is now Massachusetts, and in 1628 a charter of incorporation comprehending the powers of government was granted to the purchasers. Great part of New England was granted by this company, which at length divided the remaining lands among themselves, and in 1635 surrendered their charter to the crown. A patent was granted to Gorges for Maine, which was allotted to him in division of property. All the grants made by the Plymouth Company, as far as we can learn, have been respected. In pursuance, of the same principle, the king, in 1664, granted to the Duke of York the country of New England as far as south to the Delaware Bay. His Royal Highness transferred New Jersey to Lord Berkeley and Sir George Carteret. All right. In 1663, the Crown granted to Lord Clarendon and others the country lying between the 36th and the 36th degree of north latitude in the river St. Matthews. And in 1666, the proprietors obtained from the crown the new charter granting to them that province in the king's dominions and the North America, which lies from the 36 degrees to 30 minutes north latitude to the 29th degree, and from the Atlantic Ocean to the South Sea. Thus has our whole country been granted by the crown while in the occupation of the Indians. The grants purport to convey the soil as well as the right of dominion of the grantees. In those governments which were denominated royal, where the right to the soil was not vested in the individuals, but remained in the crown or was vested in the colonial government. The king claimed and exercised the right of granting land and dismembering the governments at his will. The grants made out to the two original colonies. Let me backtrack here. The grants made out to the two original colonies after the resumption of their charters by the crown are examples of this. The governments of New England, New York, New Jersey, Pennsylvania, Maryland, and part of Carolina were thus created. Okay, so this, all that just to say, this is how we came up with New England, New York, New Jersey, Pennsylvania, Maryland, and part of Carolina. Okay. In all of them, the soil and the time the grants were made were occupied by the Indians. Yet almost every title within those governments is dependent on these grants. In some instances, the soil was conveyed by the crown unaccompanied by the powers of the government, as in the case of the northern neck of Virginia. It has never been objected to this or to any other similar grant that the title as well as possession was in the Indians when it was made and when it passed, nothing on that account. The various patents cannot be considered as nullities. What is a nullity? I assume it means void. An act or a thing that is legally void. Yeah, okay, cool. Nor can they be limited to a mere grant of the powers of the government. A charter intended to convey political power only would never contain words expressly granting the land, the soil, and the waters. Some of them purport to convey the soil alone, and in those cases in which the powers of government as well as the soil are conveyed to individuals, the crown has always acknowledged itself to be bound by the grant. Though the power to dismember regal governments was asserted and exercised, the power to dismember proprietary governments was not claimed. Let's see, what's a proprietary government? This might actually be a term together, meaning you got to look them up. Proprietary government is a type of colonial government where land has been given to one or few individuals known as proprietors by the crown. Oh, okay. So sounds to me like it was like how nobles received land. Some notable examples of retired colonies include Pennsylvania, William Penn, and Maryland. Yeah, okay. All right. Interesting. Okay. Dismember proprietary governments was not claimed, and in some instances, even after the powers of government were reversed in the crown, okay, you're gonna see like reversal of property later. So, look like you don't have to like memorize this, but just know that it can happen, right? The title of proprietary to the soil was respected. Charles II was extremely anxious to acquire the property of Maine, but the grantees sold it to Massachusetts, and he did not venture to contest the right of that colony to the soil. The Carolinas were originally proprietary governments. In 1721, a revolution was effected by the people, who shook off their obedience to the proprietaries and declared their dependence immediately on the crown. The king, however, purchased the title of those who were disposed to sell, disposed meaning capable. One of them, Lord Carteret, surrendered his interest in the government, but retained his title to the soil. That title was respected till the Revolution, when it was forfeited by the laws of war. This is a really big deal, by the way. Like, I don't really want to get into politics, but when you think about countries going to war with each other, for example, that's how people get land. I mean, that's how countries claim land. So, food for thought. Like, sometimes war isn't necessarily because we don't get along. It's because not we specifically the United States, but white countries go to war isn't necessarily just because of they don't they're having a disagreement with another nation. Sometimes it's just trying to get their hands on land or let go of debts or whatever. Yeah, it is what it is. You know. Okay. Further proofs of the extent to which this principle has been recognized will be found in this history of the wars, negotiations, and treaties which the different nations claim territory in America have carried on and held with each other. The contests between the cabinets of Versailles and Madrid respecting the territory on the northern coast of the Gulf of Mexico were fierce and bloody, and continued until the establishment of a Bourbon on the throne produced such amicable dispositions in the two crowns as to suspend or terminate them. What does a Bourbon on the throne mean? The Bourbon of a Bourbon on the throne. I'm guessing they're not talking about alcohol here. The House of Bourbon was prominent in Europe. Okay, so it's the actual. Okay, so they're talking about a family name. Okay, the Royal Bourbons originated in 1272. Okay. Okay. All right. I was like a bourbon on the throne. Is that a descriptor? No, it's a family name. Okay. Cool. Makes sense. I'm with it. I'm tracking. All right. Let's go. All right. Produce such amicable dispositions in the two crowns as suspended or terminate them. Between France and Great Britain, those discoveries as well as settlements were nearly contemporaneous. Contests for the country actually covered by the Indians began as soon as their settlements approached each other, and were continued until finally settled in the year 1763 by the treaties of Paris. By the Treaty of Paris, not treaties. There's only one. Okay. Each nation had granted and partially settled the country, denominated by the French Acadie and by the English Nova Scotia, and by the 12th article of the Treaty of Utrecht, made in 1703, His Most Christian Majesty ceded to the Queen of Great Britain. Who is His Most Christian Majesty? I'm guessing because, and the reason why I say it is because the Queen of, like, the monarchs represent the religious leaders in Britain, I believe. That they're, like I said, the foundation of like their sovereignty as in existence basically is founded on religion. So His Most Christian Majesty, is that the king? That the king ceded to the Queen of Britain? Is that what it's saying? What does this mean? Most Christian Majesty. Oxford of reference. All right, what's this about? Cookies. That's making me hungry. A title belonging to the kings of France. Oh, okay. So this is saying that France ceded to Britain. Title belonging from 14, like Christian Majesty, His Most. It's just funny the way how it reads here. Anyway. Invariably used by the popes in addressing them. Wow, yeah, okay. So they're saying that by the 12th article of the treaty, okay, which makes sense because they're talking about the French Acadie and then the Treaty of Paris. So, okay, cool. Now I'm tracking. I'm with it. All Nova Scotia or Acadie with its ancient boundaries. A great part of the ceded territory was in the possession of the Indians, and the extent of the secession could not be adjusted by the commissioners to whom it was referred. The Treaty of Aix-la-Chapelle, I AIX. I don't know how to pronounce that. La Chapelle. I'm gonna try that. I'm gonna go with that. Which was made on the principle of the status antebellum, did not remove his subject from controversy, meaning that it did not stop the fight, right? Commissioners for its adjustment were appointed, whose very able and elaborate, though unsuccessful, arguments in favor of the title for their respective sovereigns show entirely each relied on the title given by discovery to lands remaining in the possession of Indians. After the termination of this fruitless discussion, the subject was transferred to Europe and taken up by the cabinets of Versailles and London. This controversy embraced not only the boundaries of the New England, Nova Scotia, and that part of Canada which adjoined those colonies, but embraced a whole western country also. France contended not only that the St. Lawrence was considered as the center of Canada, but that the Ohio was within that colony. She founded this claim on discovery, and having used that river for the transportation of troops in the war with some southern Indians. The river was comprehended in the chartered limits of Virginia, but though the right of England to a reasonable extent a country in the virtue of her discovery in the sea coast and of the settlements she made on it was not to be questioned, her claim of all the lands to the Pacific Ocean because she had discovered the country washed by the Atlantic might, without deteriorating from the principle recognized by all, be deemed extravagant. It interfered, too, with the claims of France founded on the same principle. She therefore sought to strengthen her original title to lands in controversy by insisting that it had been acknowledged by France in the 15th article of the Treaty of Utrecht. Utrecht. I'm gonna figure this out. The dispute respecting the construction of that article has no tendency to impair the principle that the discovery gave a title to land still remaining in the possession of the Indians. Whichever title prevailed, it was still a title to lands occupied by the Indians, whose right of occupancy neither controverted nor had then extinguished. These conflicting claims produced a long and bloody war, which was terminated by the conquest of the whole country east of the Mississippi. In the Treaty of 1763, France ceded and guaranteed to Great Britain all Scotinovia, or Acadie, and Canada, with their dependencies, and it was agreed that the boundaries between the territories of the two nations in America should be irrevocably fixed by a line drawn from the source of the Mississippi throughout the middle of that river and the lakes Maurepas and Pontchartrain to the sea. This treaty expressly cedes and has always been understood to cede the whole country on the English side of the dividing line between the two nations, although a great valuable part was occupied by the Indians. In Great Britain, on her part, surrendered to France all her pretensions to the country west of the Mississippi. It has never been supposed that she surrendered nothing, although she was not in actual possession of foot of land. She surrendered all right to the acquired country, and after an attempt to purchase it from the Indians would have been considered and treated as an invasion of the territories of France. Okay. By the 20th article of the same treaty, Spain ceded Florida, with its dependencies and all the country she claimed east or southwest of the Mississippi, to Great Britain. Great part of this territory also was in possession of the Indians. By a secret treaty which was executed about the same time, France ceded Louisiana to Spain. And Spain since retroceded the same country to France. At the same time, both of its cessions and retrocession was occupied chiefly by the Indians. Thus, all the nations of Europe, who have acquired territory on this continent have asserted in themselves and have recognized in others the exclusive right to rediscover, and the right to discoverer to appropriate the lands occupied by the Indians. Have the American states rejected or adopted this principle? Okay, so we're talking about whether or not we're going to continue this notion of acquiring territory by war, right? The right of the discoverer to appropriate the lands occupied by the Indians. Like, yeah. So they're saying other countries have done it. That means we can too, right? Like, maybe, I don't know. Can we? We have to decide if we're going to be like other countries or we're going to do things different. That seems, I don't know if I'm reading this wrong, but that seems to me like what it's saying. Maybe, I don't know. Maybe I got it right. Maybe I didn't. Okay. By the treaty which concluded the War of our Revolution, Great Britain relinquished all claim not only to the government but to the proprietary and territorial rights of the United States. Okay, so they're saying that we inherited from Britain the claim to this land that was appropriated by Britain. Right? Yeah, that's what I'm saying. Maybe I missed it, but that's what I'm saying. Whose boundaries were fixed in a second article. By this treaty, the powers of government and the right to soil, which had previously been in Great Britain, passed definitively to these states. Yeah, okay, cool. We're on the same page. Right. Okay. We had therefore taken possession of them by declaring independence, but neither the Declaration of Independence nor the treaty confirming it could give us more than that which we possessed before, possessed, or which Great Britain was before entitled. Okay, no, this is actually a really important principle in property law. You'll see more of it later, but that is to say that you can't give more than what you got. If you only own the right to occupy a land for so many years, that's all you can give to somebody else, including selling. Like, you can't give or sell. You can't transfer more than what you own. And you'll see more of that later, right? So here, like, this is important. Actually, this is super important. I don't remember if you're going to see it in other cases, but yeah. We had before taken possession of them by declaring independence, but neither the Declaration of Independence nor the treaty confirming it could give us more than which we before possessed to which Great Britain was before entitled. You're gonna want to reword this, like if you're taking an exam for property law, you literally want to word it as a grantor, meaning somebody who is giving or selling to someone else land, especially land. It's the same thing with personal property, but land is where you like really see these caveats because there's been so many fights over it. The grantor cannot give away more rights than what they possess. So what you'll see in some cases is where somebody gives away a right of nothing. So they're like, I give you everything I own. And it turns out they actually own nothing. And they give it away. And the other person's like, yeah, I own the whole thing because this other person gave me everything they own. And then you go to look at it and you go, well, they gave you everything they own. Yes, but what they own was nothing. So what you what you own is nothing because they gave you all of nothing. They gave you 100% of zero possession. So you own all 100% of the zero that they possessed. And that's what this is talking about. Cool? Cool. All right, let's get moving. It has never been doubted that either the United States or several states had clear title to all the lands within the boundary lines described in the treaty, subject only to the Indian right of occupancy. Okay, yeah. So, and this is what we're talking about. Like, you can be allowed to occupy but not own land. And so you'll look at that later. Like, um, you'll see cases later where it's like you were allowed to occupy but not to own. So you can't give more than what you're allowed to do, than what you have rights to. That's kind of, by the way, what, if you look at real estate, this is what I'm talking about. Like, nobody really owns land in the U.S. They don't really own it. They kind of just have like a right to occupancy until the government says otherwise. Now, there is rights that come with purchasing uh, from them, but yeah, like don't be blind. Like, know what you're buying. Like, really know what you're buying, because it's probably not what you think. Okay. And that exclusive power to extinguish that right was vested in the government, which might constitutionally exercise it. Virginia, particularly within whose chartered limits the land in controversy lay, passed an act in the year 1779 declaring her exclusive right of preemption from the Indians of all the lands within the limits of her own chartered territory, and that no person or persons whatsoever have or ever had a right to purchase any lands within the same from any Indian nation except only persons duly authorized to make such purchase, formerly for the use and benefit of the colony and lately for the Commonwealth. So this is very specific language for authorization. Cool. The act then proceeded to annul all deeds made by Indians and to individuals for the private use of the purchasers. Without ascribing to this act, I think I know what ascribing is, but let's just check and make sure because I don't want to have any crazy surprises. To attribute to, yeah, okay. Attribute to something. Without ascribing to this act the power of annulling vested rights or admitting it to countervail the testimony furnished by the marginal note opposite to the title of law forbidding purchases from the Indians in the revisals of the Virginia statutes, stating that law to be repealed, it may safely be considered as an unequivocal affirmance of on the part of Virginia on the broad principle which had always been maintained that the exclusive right to purchase from the Indians resided in the government. Okay. In pursuance of the same idea, Virginia proceeded with this at the same session to open her land office for the sale of that country which now constitutes Kentucky, a country every acre of which was then claimed and possessed by the Indians, who maintained their title with as such persevering courage as was ever manifested by any people. So I don't know if this means going to war. What year was this? Because man, there was some real like bloody wars around this time frame. I mean, the decision was in 1823, and they're talking about the past still. So yeah, they're saying. I think if I'm reading this right, that the Native American people, rightfully so, didn't want to give up their land, so they fought for it. Okay. The states, having within their chartered limits different portions of the territory covered by Indians, ceded that territory generally to the United States on conditions expressed in their deeds of secession, which demonstrate the opinion that they ceded the soil as well as jurisdiction, and that in doing so, they granted a productive fund to the government of the Union. The lands in controversy lay within the chartered limits of Virginia and were ceded with the whole country northwest of the River Ohio. The grant contained reservations and stipulations which could only be made by the owners of the soil, and concluded with a stipulation that all lands in the ceded territory not reserved should be considered as a common fund for the use and benefit of such of the United States as have become or shall become members of the Confederation. according to their usual respective proportions and in the general charge and expenditure, and shall be faithful and bona fide disposed of for that purpose, and for no other use or purpose whatsoever. Hmm. What are they talking about here? What's this? And all the land ceded and territory not reserved should be considered as a common fund for the use and benefit of such of the United States as have become or shall become members of the Confederation. Okay. So if I'm reading this correctly, this is the portion of law that says that um, that talks about what Native Americans are allowed to do on like the land and what they're not allowed to do. I could be very wrong. I'll have to like look into this more, but it seems to me like that's what it's talking about. That is this, which demonstrated the opinion in which they see this jurisdiction. Yeah, okay. The lands in controversy lay within the charter limits of Virginia, which were ceded with the whole country in Northwest, would contain reservations and stipulations which could only be made by the owners of the soil, and concluded with a stipulation that all lands ceded territory not reserved should be considered as a common fund for the use and benefit of such a United States. Oh no, okay, so this is just a language. I take that back. This is the language that was in the treaty that gave, um, in which the U.S. um, claimed the land. Um, yeah, as part of the treaty. Okay, the ceded territory was occupied by numerous and warlike tribes of the Indians, but the exclusive right of the United States to extinguish our title and to grant the soil was never, we believe, been doubted. For these states became independent, a controversy subsisted between them and Spain respecting boundary. By the Treaty of 1795, this controversy was adjusted, and Spain ceded to the United States the territory in question. This territory, though claimed by both nations, was chiefly in the actual occupation of Indians. The magnificent purchase of Louisiana was a purchase from France of a country almost entirely occupied by numerous tribes of Indians whom are in fact independent. Why throw in this magnificent word in here? Are they saying like, wow, it was such a good deal? What, like, I feel like I'm missing something here. I mean, maybe I'm just reading too much into it, but let me see if there's another definition for magnificent. Now it got me wondering. Massive. Okay, exceptionally beautiful, impressive, or grand. Very good, excellent. Okay. Great indeed, or exalted in place. Okay, deed is an action, not a title, not like a used formally. Oh, okay, no, this is okay. Never mind. Marked by stately grandeur of lavishness, sumptuous in structure and adornment. Broadly striking, beautiful, and impressive to the mind of the spirit. Let me see if there's a separate um, legal definition. Okay. It doesn't look like it, but you really never know. Like there's, like I guess I should look at like Black's Law Dictionary. Okay, it doesn't look like it. So they're just literally saying like it was a really big purchase. And I don't know if that means big as in like the purchase amount was big, the size of the land was big. I don't know necessarily what they're talking about here. So, okay. It's kind of rare for, at least as far as I can tell, that I've seen in like later cases. It's relatively unusual for judges describe describe like almost an emotion. I don't know how else to say it. To describe an emotion uh, of a transaction, unless it was like legally significant. So maybe they're saying that this was such a great big purchase of legal significance. That could be. Let's see. Okay. Yeah, any attempt of those to intrude into that country would be considered an aggression which would justify war. Okay. So now I see why they put this in here. They were saying that they made this great big purchase of Louisiana from France, but if anybody tried to step into Louisiana, they'd basically be at war with these tribes. And to an extent, they're almost saying like, what do we actually buy? What, like, we bought it, it's ours, give it to us, right? I don't know if maybe by saying this that they're saying that like France owed them a occupiable land by purchasing it. Like, of are they claiming ignorance of the fact that there was Indian tribes there and that stepping foot on there would be like an invasion of where they lived essentially? Like, okay, this is the easiest way for me to like explain this one, and not to compare Native Americans to animals. Okay, I don't want people thinking that that's what I'm doing here, but not but the the way to think about this is the tribes they didn't really recognize like American law or British law, in part because, well, they didn't grow up under that system, right? And so you can try to impose a legal system on a people, but if, first of all, if they're not aware of it, they're not going to understand it. And even if they understand, it doesn't mean they're going to accept it without a fight. You know, if you walk into a cave and in the cave lives a bear, even if you own the cave and you bought it from that, natural preserve, that bear is going to fight you. Like, don't be surprised, right? And let's not pretend like we're surprised. So, again, not to compare Native Americans to bears, um, though I don't know if they would be upset if I did. I know bears are very spiritual animals, so hey, maybe they would appreciate that. I don't know. Okay. Um, our late acquisition from Spain are of the same character, and the negotiations which preceded those acquisitions recognize and elucidate the principle which has been received by the foundation of all European title in America. The United States then has unequivocally acceded to that great and broad rule by which its civilized inhabitants now hold this country. They hold and assert in themselves the title by which it was acquired. They maintain, as all others have maintained, that discovery gave an exclusive right to extinguish the Indian title of occupancy either by the purchase or by the conquest, and also gave right to such a degree of sovereignty as the circumstances of the people would allow them to exercise. So they're saying, like, no matter which route you go, like we own this territory, like, or rather, they're not saying that we own this territory, but that those tribes that previously had right to that title, they lost it. They lost the right, either because they sold it or because they lost in war. So the courts This is something that courts do. If they're actually like, if you look at really well written cases, the judges or justices, they almost always like attack the issue from like all avenues. Um, and I don't know how much of that is the judges and how much of that is the attorneys. Um, but they'll try to, like, if we can't go in, like if this path is blocked, then we'll try this one, and if this path is blocked, then we'll try that one. And so they tried both paths here, right? They're saying like there's two ways to get land. You can either buy it or you can go to war for it. Like give them money, or I don't know, kill them. Basically, is what they're saying. Like there's two ways to acquire land. And in these particular lands that we're discussing, they're saying that these Native Americans lost the right by both purchase and by conquest. Like the discovery of exclusive right to extinguish by either person. Yeah, so they're saying both ways, no matter how you look at it, they lost title. So they have no right to title. Yeah, okay. The power now possessed by the government of the United States to grant lands resided while we were colonies in the crown or its grantees. The validity of the titles given by either has never been questioned in our courts. It has been exercised uniformly over the territory and possession of the Indians. The existence of this power must negative in the existence of any right which may conflict with it, which may conflict and control it. An absolute title to land cannot exist at the same time in different persons or in different governments. This is actually really important. So you'll see later, like you'll hear terms like fee simple absolute, right? And fee simple absolute means that you hold a complete ownership up to the laws that are allowed, So if you own your house free and clear, then you own a free you own a fee simple absolute, right? And in order to have a fee simple absolute, no one else can have a claim to that spot. Like that's your kick it spot, that's yours. No one else's. Okay. That's what they're saying. So an absolute title to lands cannot exist at the same time in different persons. Only one person, and by the way, married couples would be basically considered one person, like one entity, or one government, right? That's how that would be. Okay. An absolute must be exclusive title, or at least a title which excludes all others not compatible with it. All our institutions recognize the absolute title of the crown, subject only to the Indian right of occupancy, and recognize the absolute title of the crown to extinguish that right. This is incompatible with an absolute and complete title in the Indians. So they're saying it can either be either or. It can't be both. Either the Indians own it or the crown owned it, which we inherited from. Or not inherited, but in this case, through the Revolutionary War, was ceded to us, right? Okay. We will not enter into controversy whether agriculturists, merchants, and manufacturers have a right on abstract principles to expel hunters from the territory they possess or contract their limits. Conquest gives a title which the courts of the conqueror cannot deny. Okay, so they're saying whoever wins the war, they can't deny these conquests, right? Okay. Yeah. Whatever the private and speculative opinions of the individuals may be, respecting the original justice of the claim which has been successfully asserted. The British government, which was then our government and whose rights have passed to the United States, asserted title to all the lands occupied by the Indians within the charted limits of the British colonies. It asserted also a limited sovereignty over them and exclusive right of extinguishing the title which occupancy gave to them. These claims have been maintained and established as far west as the Mississippi by the sword. I'm guessing this means by war. Okay. The title to a vast portion of the lands we now hold originates in them. It is not for the courts of this country to question the validity of this title or to sustain one which is incompatible with it. Although we do not mean to engage in the defense of those principles which Europeans have applied to Indian title, they may, we think, find some excuse, if not justification, in the charter and the habits of the people whose rights have been wrestled from them. What does that mean? What does that mean? What are they talking about here? Although we do not mean to engage in defense of the principles of Europeans of applying in their title, they may, we think, in some excuse, if not justification, in the character. Woo. Okay, all right. In the character and the habits of the people whose rights have been wrestled from them. Okay. I read charter earlier and I was like, the charter? What? Okay. The right in conquest is acquired by and maintained by force. The conqueror prescribes its limits, okay? To the winner goes the spoils, right? Humanity, however, acting on public opinion, has established as a general rule that the conquered shall not be wantonly oppressed. Okay, all right. And that their condition shall remain as eligible and as compatible with the objects of the conquest. Most usually, they are incorporated with the victorious nation. Okay, so they're saying like most usually whoever loses a war gets I don't want to say they become refugees, like that's a totally different. I'm sure there's like a legal definition for that, but they get synthesized with the people of the conquering nation. Is if I'm reading this correctly, that's what. So I mean, this is almost like I don't want to say it's an immigration principle, but the new and the old members of society mingle with each other. Yeah, okay. Um, it becomes subject to citizens of the government which they were connected. Yeah. So yeah, okay. I was gonna say this like it's almost like saying like if you get conquered by if a nation gets conquered by say like for example another country or another government, then the new government gains title to that land, but the people that belong to the old nation usually get incorporated. Well, that's exactly what I said. Incorporated with the victorious nation, so they they become, I guess, they gain citizenship. And I don't know if citizens of the government, which they are connected. I don't know if we're talking about the same kind of citizenship. I mean, like, are we talking about like the Roman style of citizenship, where like not everybody there, not everybody who lived there was necessarily a citizen? Are we talking about citizenship as in like a permanent, unchallenged residency? Like, what are we talking about here? Are we talking about voting rights? Are we talking about what are we talking about? I don't know. And this is what I'm talking about. Like, this is why it's important to know the time and the place of where something occurred, because depending on these two things will depend on what it means to be a citizen. Make sense? And I know this all sounds relatively mundane or like it's not really important, but knowing these things, um, knowing these sorts of things will greatly impact how future cases are seen and argued. Um, we are, if as you'll see much later, like we are. I don't want to say stuck in tradition. That's the wrong way to say it. We are, as a profession, we are originalists. I mean, you'll see like Scalia like really hammered on this. Justice Scalia really hammered on this later. But we yeah, we like to look at the old document and its context and what it meant for the time, and based on that, um, is what we say that that's what the law would mean in modern days, right? And you really see this, you really see this a lot recently, as of recent times, in regards to like Second Amendment stuff, for example, right? Like, and they'll argue there's two sides, obviously. Um, one that says, nobody had semi-automatic, or nobody had pistols the same way in the 1800s when America was first founded, uh, or actually it was 1700s when it was founded. Um, like nobody had that. Like people had muskets, and so that means that your right to bear arms is to bear a musket. That's one side, and then the other side was they would look at the context, right? Like, yeah, we were talking about people bearing muskets because that's what was available at the time. If it was bow and arrow at the time, that was the available technology for somebody to bear arms, then that's what we would be talking about. We would be talking about bows and arrows. If we're talking about rifles, then we're talking about rifles. If we're talking about, um, if for the time it's like, I don't know, laser pistols in the future, then it would be covered by the Second Amendment, because that's the context matters. If you're talking about how to interpret these types of cases, the context really matters. It matters less that uh, it matters less that when it was written, they didn't expect people to build like laser weapons in the future. What matters is the principle of the matter. It's the easiest way to explain it. So if in the future laser pistols are um, something that is available, then and that's what's modernly capable of being used, and that's what it would be. So knowing what this is my point, like knowing what citizens of the government means in that time frame, like what that context was, is actually kind of important. And I don't know the answer to that, but it's something to look at. Now I know that, like if you're a 1L right now and you're looking at this and you're like, oh, I gotta find out what citizen. No, no, not quite. They're probably not gonna test you on this. I'm just being very real. But if you were to have a Supreme Court case that you had to argue, you should be paying attention to this. You know, like if you're gonna go before the Supreme Court and you're building arguments and you're trying to figure out, like, what am I gonna say? This is something that you would look at, and it sounds crazy, but even something as small as like what definition of citizens was being used, that could be the chief argument in a Supreme Court case. And that could be what makes the difference between whether your party loses or wins. So, yeah, pay attention to that stuff. The new and the old members of the society mingle with each other. The distinction between them is gradually lost, and they make one people. Where this incorporation is practicable, yeah, practicable, yeah, practicable. All right. Let me back up. Where this incorporation is practicable, humanity demands, and a wise policy requires, that the rights of the conqueror to property should remain unimpaired. Where the new subject should be governed is equitably as the old, and that confidence in their security should gradually banish the painful sense of being separated from their ancient connections and united by force to strangers. So they're saying like they should, like a conquering nation should, set up systems where the people who are conquered become their new people, and their old government basically dies. Okay. When the conquest is complete and the conquered inhabitants can be blended with the conquerors or safely governed as a distinct people, public opinion, which not even the conqueror can disregard, imposes these restraints upon him, and he cannot neglect them without injury to his fame or hazard to his power. But the tribes of Indians inhabiting this country were fierce savages whose occupation was war and whose subsistence was drawn chiefly from the forest. To leave them in possession of their country was to leave the country a wilderness. To govern them as a distinct people was impossible because they were as brave and as high spirited as they were fierce, and were ready to repel any by arms every attempt on their independence. Okay, so they were saying, at least this portion, they're saying like we tried, we tried to do what old Daddy Britain taught us to do about how to build empires and how to like um, bring in new people and indoctrinate them, but Native Americans were ungovernable because they were too independent. They'd rather die. They'd rather die than to give it up, basically. So they had to take a different approach. Yeah. Okay. What was the inevitable consequence of the state of things? The Europeans were under the necessity either of abandoning the country and relinquishing their pompous claims to it, or enforcing those claims by the sword, and by the adoption of principles adapted to the condition of a people with whom it was impossible to mix and who could not be governed as a distinct society, or of remaining in their neighborhood and exposing themselves and their families to the perpetual hazard of being massacred. uh, being master. Yeah, okay. Frequent and bloody wars in which the whites were not always the aggressors unavoidably ensued. European policy, numbers, and skill prevailed. As the white population advanced, that of the Indians necessarily receded, and the country in immediate neighborhood of agriculturists became unfit for them. The game fled into thicker and more unbroken forests, and the Indians followed. The soil to which the crown originally claimed title, being no longer occupied by its ancient inhabitants, was parceled out according to the will of the sovereign power and taken possession of by persons or claimed immediately from the crown or mediately through its grantees or deputies. The law which regulates and ought to be, and ought to regulate in general in relations between the conqueror and the conquered was incapable of application to a people under such circumstances. The resort to some new and different rule better adapted to the actual state of things was unavoidable. Every rule which can be suggested will be found to attended with great difficulty. However extravagant the pretension of converting the discovery of an inhabited country into conquest may appear, if the principle had been asserted in the first place and afterwards sustained, if a country has been acquired and held under it, if the property of the great mass of the community originates in it, it becomes the law of the land and cannot be questioned. So too with respect to the concomitant. Is that commitment? What is this? Concomitant. Naturally accompanying or associated. Okay. Naturally accompanying or associated. A phenomenon that naturally accompanies or follows something. Okay. Principle that the Indian inhabitants were to be considered merely as occupants, to the protected indeed while in peace in the possession of their lands, but to be deemed incapable of transferring the absolute title to others. However, this restriction may be opposed to natural right and to the usages of civilized nations. Yet, if it be indispensable to that system under which country has been settled, and be adapted to the actual condition of the two people, It may perhaps be supported by reason and certainly cannot be rejected by courts of justice. This question is not entirely new in this court. The case of Fletcher versus Peck grew out of the sale made by the state of Georgia of a large tract of country within the limits of that state, the grant of which was afterwards resumed. The action was brought by a sub-purchaser of the contract of sale, and one of the covenants in the deed was that the state of Georgia was, at the time of sale, seized in fee of the premises. The great question presented by the issue was whether the seizing in fee was in the state of Georgia or in the United States. Okay. Oh, because they hadn't transferred the property right yet. Okay. After stating that this controversy between the several states in the United States had been compromised, the court thought it necessary to notice the Indian title, which, although entitled to the respect of all courts until it should be legitimately extinguished, was declared not to be such as to be absolutely repugnant to a seizing in fee on part of the state. This opinion conforms precisely with the principle which has been supposed to be recognized by all European governments from the first settlement of America. The absolute ultimate title has been considered as acquired by discovery, subject only to the Indian title of occupancy, which title the discoverers possess the exclusive right of acquiring. Such a right is no more incompatible with a season in fee than a lease for years, which may be effectually bar an ejectment. Okay. Another view has been taken of this question, which deserves to be considered. The title of the crown, whatever it might be, could be acquired only by a conveyance from the crown. Remember, you can only give what you got, right? If an individual might extinguish the Indian title for his own benefit, or in other words, might purchase it, still he could acquire only that title. Admitting their power to change their laws or usages so far as to allow an individual to separate a portion of their lands from the common stock and hold it in severalty, still it allows a part of their territory and is held under them by a title dependent on their laws. The grant deserves its efficacy from their will, and if they choose to resume it and make a different disposition of the land, the courts of the United States cannot interpose the protection of the title. The person who purchases lands from the Indians within their territory incorporates himself with them so far as respects to the property purchased, holds their title under the protection and subject to their laws. If they annul the grant, we know of no tribunal which can revise and set aside the proceeding. We know of no principle which can distinguish this case from a grant made to a native Indian, authorizing him to hold a particular tract of land in severalty. As such a grant could not separate the Indian from his nation, nor give a title which our courts could distinguish from the title of his tribe, it still might. Let me backtrack here. As such a title could not separate the Indian from his nation, nor give a title which our courts could distinguish from the title of his tribe, as it might still be conquered from or ceded by his tribe, we can perceive no legal principle which will authorize a court to say that different consequences are attached to this purchase because it was made by a stranger. By the treaties concluded between the United States and the Indian nations whose title the plaintiffs claim, the country comprehending the lands in controversy has been ceded to the United States without any reservation of their title. These nations had been at war with the United States and had an unquestionable right to annul any grant they had made to the American citizens. Their cessation of the country without a reservation of this land affords a fair presumption that they considered it as of no validity. They ceded to the United States this property after having used it in common with other lands as their own from the date of their deeds to the time of cessation, and the attempt now made is to set up their title against that of the United States. The proclamation issued by the King of Great Britain in 1763 has been considered, and we think with reason, as constituting an additional objection to the title of the plaintiffs. By that proclamation, the Crown reserved under its own dominion and protection for the use of the Indians all the lands and territories lying to the westward of the sources of the rivers which fall into the sea from the west and northwest, and strictly forbade all British subjects from making any purchases or settlements whatever, or taking possession of the reserves lands. It has been contended that in this proclamation the king transcended his constitutional powers, and in the case of Campbell versus Hall, reported by Cowper, is relied on to support this position. It is supposed to be a principle of universal law that if an uninhabited country be discovered by a number of individuals who acknowledge no connection with and owe no allegiance to any government whatsoever, the country becomes the property of the discoverers, so far at least as they can use it. They acquire a title in common. Okay, this is a title in common for by these individuals. So it is supposed to be a principle of universal law that if an uninhabited country discovered by a number of individuals who acknowledge no connection and owe no allegiance to any government whatsoever. So this is like a free people who have no country. So if more than one person, a number of individuals who owe no allegiance basically to any crown, any government to be specific, that country becomes the property of the discoverers, and they get title in common. Now there's something called tenants in common. That's a type of title for like houses and stuff. So maybe that's where this came from. But now we're talking about owning land, not just being tenants. So different, but same. But is it the same difference? That's, I guess, really the question, right? Okay. The title of the whole land is in the whole society. It is to be divided and parceled out according to the will of the society, expressed by the whole body or by that organ which is authorized by the whole to express it. If the discovery be made and possession of the country be taken under the authority of the existing government, which is acknowledged by the emigrants, it is supposed to be equally well settled, and the discovery is made for the whole nation, that the country becomes part of the nation, and that the vacant soil is to be disposed by that organ of the government, which is the constitutional power to discover the national domains, and that organ in which all vacant territory is vested by law. According to the theory of British Constitution, all vacant lands are vested in the crown. This is actually what I was talking about earlier, like way at the beginning, like the king owned everything. So, boom. As representing the nation, an exclusive power to grant them is admitted to reside in the crown as a branch of the royal prerogative. It has been already shown that this principle was as fully recognized in America as in the island of Great Britain. All the lands we hold were originally granted by the crown, and the establishment of a regal government has never been considered as impairing its right to grant lands within the chartered limits of such colony. In addition to the proof of this principle, furnished by the immense grant already mentioned of lands lying within the chartered limits of Virginia, the continuing right of the Crown to grant lands lying within that colony, uh, was always admitted. A title may be obtained either by making an entry with the surveyor of a country in pursuance of law, or by an order of governor and council, who was the deputy of the king, or by an immediate grant by the crown. In Virginia, therefore, as well as elsewhere in British dominions, the complete title of the crown to vacant lands was acknowledged. So far as respected the authority of the crown, no distinction was taken between vacant lands and lands occupied by the Indians. Yes, occupied by the Indians. The title, subject only to the right of occupancy by the Indians, was admitted to be in the king, as was his right to grant that title. The lands, then, to which this proclamation referred were lands which the king had right to grant or reserve for the Indians, According to the theory of the British Constitution, the royal prerogative is very extensive so far as respects the political relations between Great Britain and foreign nations. The peculiar situation of the Indians necessarily considered in some respects as a dependent and in some respects as a distinct people occupying a country claimed by Great Britain, and yet too powerful and brave not to be dreaded as formidable enemies, required that means should be adopted for the preservation of peace, and that their friendship should be secured by quieting their alarms for their property. This was to be effected by restraining the encroachments of the whites, and the power to do this was never, we believe, denied by the colonies to the crown. Okay. In the case of Campbell versus Hall, that part of the proclamation was determined to be illegal, which imposed a tax on the conquered province after a government had been bestowed upon it. The correctness of this decision cannot be questioned, but its application to the case at bar cannot be admitted. Since the expulsion of the Stuart family, the power of imposing taxes by proclamation has never been claimed as a branch of regal prerogative, but the powers of granting or refusing to grant vacant lands and of restraining encroachments on the Indians have been asserted and admitted. The authority of this proclamation, so far as respected this continent, has never been denied, and the titles it gave to lands have always been sustained in our courts. The argument of this cause, the counsel for which plaintiffs have relied very much on the opinions expressed by the men holding offices of trust, and on various proceedings in America to sustain titles to land derived from the Indians. The collection of claims to lands lying in the Western country have made in the first volume of the Laws of the United States have been referred to, but we find nothing in that collection to support the argument. Most of the titles were derived from the persons professing to act under the authority of the government existing at the time, and the two grants under which the plaintiffs claim are supposed by the person under whose inspection the collection was made to be void, because forbidden by the royal proclamation of 1763. They're talking about like who actually like had authority to act on behalf of the crown. So there were people that were claiming to, if I'm reading this correctly, who were claiming to be acting on behalf of the crown, and they were like, maybe they were, maybe they weren't. So yeah. It is not unworthy of remark that the usual mode adopted by the Indians for granting lands to individuals has been to reserve them in a treaty or grant them under the sanction of the commissioners with whom the treaty was negotiated. The practice, in such case, to grant to the crown for the use of the individual is evidence of some general understanding that the validity even of such a grant depended on receiving the royal sanction. The controversy between the colony of Connecticut and the Mohegan Indians depended on the nature and extent of the grant made by those Indians to the colony. On the nature and extent of the reservations made by the Indians in their several deeds and treaties, which were alleged to be recognized by the legitimate authority, and on the volition by the colony of rights thus reserved and secured. We do not perceive in that case any assertion of the principle that individuals might obtain complete and valid title from the Indians. It has been stated that the memorial transmitted from the Cabinet of London to that of Versailles, so that's going to be a written document. We're not talking about like a funeral or anything like that. During the controversy between the two nations respecting boundary, which took in 1755, and the Indians' right to soil is recognized. But this recognition was made with a reference to their character as Indians and for the purpose of showing that they were fixed to a particular territory. It was made for the purpose of sustaining the claim that His Britannic Majesty to dominion over them. Okay, so this is talking about like, okay, we agreed to something, but we expected you to integrate into our people, and you're not doing that. Okay. The opinion of the attorney and the Solicitor General, Pratt and York, have been adduced. What is this? Adduced? Adduced. That almost sounds like do in French. Cite as evidence. Interesting. I did not know that this was a word for. Cool. Or when I first looked at this, I probably came across it and quickly forgot about it because I never saw it again. Can you imagine using this word in court? It is adduced. The judge would be like, come again? Yeah, let's see. Okay. The opinion of the Attorney and Solicitor General Pratt and York have been adduced to prove that in the opinion of those great law officers, the Indian grant could convey a title to the soil without a patent emanating from the Crown. The opinion of those persons would certainly be of great authority on such a question, and we were not a little surprised when it was read at the doctrine it seemed to advance. An opinion so contrary to the whole practice of the Crown and to the uniform opinions given on all other occasions by its great law officers ought to be very illicit and accompanied by the circumstances under which it was given, to which it was applied before we can be assured that it is properly understood. In a pamphlet written for the purpose of asserting the Indian title, styled Plain Facts, the same opinion is quoted, and it is said to relate to purchases made in the East Indies. It is, of course, entirely inapplicable to purchases made in America. Chalmers, or Commerce, I don't know how to pronounce that, Chalmers? Wait a minute, is this a word or is this a name? I guess it is actually, is a name. Servant of the Chambers? Okay, it's a name. It seems like, okay. In whose collection this, oh, right, okay, yeah, it's a name. Okay. Chalmers, in whose collection this opinion is found, does not say to whom it applies, but there is reason to believe that the author of Plain Facts is, in this respect, correct. The opinion commences thus. In respect to such places as have been or shall be acquired by treaty or grant from any of the Indian princes or governments, your Majesty's letters patent are not necessary. The words princes or governments are usually applied to the East Indians, but not to those of North America. We speak of their sachems, their warriors, their chieftains, their nations or tribes, not their princes or governments. Okay? Let's see why this distinction matters. The question on which the opinion was given to and to which it relates was whether the king's subjects carry with them the common law, which wherever they may find from whichever they may form settlements. The opinion is given with a view to this point, and is subject and is object uh, and its object must be kept, and its object must be kept in mind while construing its expressions. Much reliance is also placed on the fact that many tracts are now held in the United States under the Indian title, the validity of which is not questioned. Before the importance attached to this fact is conceded, the circumstances under which such grants were obtained and such titles are supported ought to be considered. These lands lie chiefly in the eastern states, and it is known that the Plymouth Company made many extensive grants which, from their ignorance of the country, interfered with each other. It is also known that Mason, to whom New Hampshire and Gorges, and to whom Maine was granted, found great difficulty in managing such unwieldy property. The country was settled by emigrants, some from Europe, but chiefly from Massachusetts, who took possession of lands they found unoccupied and secured themselves in that possession by the best means in their power. The disturbances in England and in the Civil War and Revolution which followed those disturbances prevented any interference on the part of the mother country. And the proprietors were unable to maintain their title. In the meantime, Massachusetts claimed the country and governed it. As her claim was adversary to that of the proprietors, she encouraged the settlement of persons made under her authority, and encouraged likewise their securing themselves in possession by purchasing the acquiescence. I'm guessing that's acquisition, but the reluctant acceptance of something without protest. Okay, acquiescence, not okay, acquiescence. Okay, by purchasing the acquiescence and forbearance of the Indians. After the restoration of Charles II, Gorges and Mason, when they attempted to establish their title, found themselves opposed by men who held under Massachusetts and other Indians and under the Indians. The title of the proprietors was restricted, and though in some cases compromises were made, and in some the opinion of the court was given ultimately in their favor, the juries found uniformly against them. They became wearied with the struggle and sold their property. So they were just like, we give up. They're not siding with us. The juries of the courts are not siding with us. And here's something to consider too. Like, I can see why they're even mentioning this. Like, who are the juries made up of? Like, in American courts, are juries made up of Native Americans, or are they made up of people of European descent who fought against Native Americans? Like, so yeah, the juries are going to side against them more than likely, and we can try to say that that they were unbiased, or try to be unbiased. Like, you can try to be unbiased, but there's so much propaganda against Indians at the time that, yeah, I mean, what are the chances that they're going to prevail in court? So yeah, yeah, I could see that. Okay, they became weary with the struggle and sold their property. The titles held under the Indians were sanctioned by length of possession and were, but there is in no case, so far as we are informed, of a judicial decision in their favor. Okay. Much reliance has also been placed on a recital contained in the Charter of Rhode Island, and on a letter addressed to the governors of the neighboring colonies by the king's command, in which some expressions were inserted, indicating the royal appropriation of titles acquired from the Indians. The Charter of Rhode Island recites: that the said John Clark and others had transplanted themselves into the midst of Indian nations, and were seized and possessed by purchase and consent of said natives to their full content of such islands, of such lands. Okay, and C, and the letter recites that Thomas Chiflinth and others having in the right of Major Asperton a just property in the Narragansett country in New Ireland, and by grants from the native princess of that country, meaning the ruling class of that country, and being desirous, having or characterized by desire, yeah, okay, desirous to improve it into an English colony, and yet daily disturbed, yeah. The impression this language might make, if viewed apart from the circumstances under which it was employed, will be effected when considered in connection with those circumstances. In the year 1635, the Plymouth Company surrendered their charter to the crown. About the same time, the religious dissensions of Massachusetts expelled from that colony several societies of individuals, one of which settled in Rhode Island on lands purchased from the Indians. They were not within the charter limits of Massachusetts, and the English government was too much occupied at home to bestow its attention on the subject. There existed no authority to arrest their settlement of the country. If they obtained Indian title, there were none to be asserted in the title of the crown. Under these circumstances, the settlement became considerable, meaning big. Individuals acquired separate property in the lands which they cultivated and improved. A government was established among themselves, and no power existed in America which could rightfully interfere with it. Okay, which settlements are they talking about here? Did I miss something? Okay. They were not charter limits in Massachusetts in the okay. So they were saying that like Native Americans were not like Britain wasn't really governing the Indians because they were busy with other stuff back in Britain. So during that time, they got really big, and America didn't have any power to really fight them, the Native Americans. Okay. At least that's how I understand it. Maybe I missed something. On the restoration of Charles II, this small society hastened to acknowledge his authority and to solicit his confirmation of their title to the soil and to jurisdiction over the country. Their solicitations were successful, and a charter was granted to them containing the recital which had been mentioned. Okay. It is obvious that this transaction can amount to no acknowledgement that the Indian grant could convey a title paramount to that of the crown, or could itself constitute a complete title. Okay, it is obvious that this transaction can amount to no acknowledgement that the Indian grant could convey title paramount to that of the crown. Paramount, I'm assuming, meaning significant. Let me see if paramount does it? Yeah, of course. More important than anything else. Yeah, supreme. So yeah, it's the significance. Okay. Or could itself contribute? Okay, so they're saying like they try to get title, but it's not a complete title. Well, I'm literally just saying the same thing twice, but it wasn't sufficient. It wasn't sufficient to be what would be an absolute ownership of that land. Okay. On the contrary, the Charter of the Crown was considered as indispensable to its completion. Okay. If it had never if it has never been contended that the Indian title amounted to nothing, their right of possession has never been questioned. The claim of government extends to the complete ultimate title, charged with its right of possession and the exclusive power of acquiring that right. The object of the crown was to settle the sea coast of America, and when a portion of it was settled, without violating the rights of others by persons professing their loyalty, and soliciting the royal sanction of an act, the consequences which were ascertained to be beneficial, it would have been as unwise and it would have been as unwise as ungracious to expel them for their habitations, because they had obtained the Indian title otherwise. Excuse me, because they had obtained the Indian title otherwise than through the agency of the government. The very grant of a charter is an assertion of the title of the crown, and its words convey the same idea. The crown granted is said to be our island called Rhode Island, and the charter contains an actual grant of the soil as well as the powers of government. The letter was written a few months before the charter was issued, apparently at the request of agents of the intended colony. Yeah, okay. Yeah. For the sole purpose of preventing the trespasses of neighbors who were disposed to claim the same authority over some authority over them. Remember that there can't be more than one owner in order for there to be an actual ownership, right? The king, being willing himself to ratify and confirm their title, was of course inclined to quiet them in their possession. The charter and this letter certainly sanctions a previous unauthorized purchase from Indians under the circumstances attending that particular purchase, but are far from supporting the general proposition that a title acquired from the Indians would be valid against a title acquired from the crown, or without the confirmation of the crown. The acts of the several colonial assemblies prohibiting purchases from the Indians have also been relied on as proving that independent of such prohibitions, Indian deeds would be valid. But we think this fact at most equivocal. While the existence of such purchases would justify the prohibition, even by colonies which considered Indian deeds as previously invalid, the fact that such acts have been generally passed is strong evidence that the general opinion that such purchases are opposed by the soundest principles of wisdom and national policy. Okay. What are they getting at over here? What are they trying to say? I feel like they're trying to tell me something and they're just it's like, okay, say it already. What are you trying to say here? Court. Tell me what you want to tell me. Okay, so they're saying that there's acts that have been passed. That prohibit these purchases. At least that's what I'm getting out of it. I think I'm gonna have to look into this a bit more because I'm not really I feel like I'm still missing something here. Okay, let's get moving. After bestowing on this subject a degree of attention which was more required by the magnitude of the interest in litigation, and the able and elaborate arguments of the bar than by its intrinsic difficulty, the court has decidedly of opinion that the plaintiffs do not exhibit title in which can be sustained in courts of the United States, and there is no error in the judgment which was rendered against them in the District Court of Illinois. Judgment affirmed with costs. Okay, man, that I guess was long, huh? I mean, this is almost as long as Marbury versus Madison, which, I mean, these are founding documents, and they were, again, really trying to make sure that that their court system was thorough, because this is all foundational, obviously, right? Okay, so what exactly did they come to? Judgment affirmed with costs. So they did not overturn the district courts. Okay. This is, by the way, like, this is what you would be looking at. If you're 1L, like, you basically want to go all the way down to the bottom of this thing and say, okay, it was affirmed. So that means that the court agreed. They're not changing anything. Okay. And that likely means that whatever the rationale was before, there's nothing to argue against. So all this is just they're just agreeing with the prior court. Yeah, and it's important to know, because if there was a reversal, at least in my experience, if there was a reversal, then it may be counterintuitive to what was being seen before. So they affirmed the judgment. After bestowing on this subject a degree of attention which was more required by the magnitude of interest in the litigation and the able and elaborate arguments of the bar than by its intrinsic difficulty, the court has decided the opinion of the plaintiffs do not. So literally, they're saying, okay, we'll look at the case because you really asked us to, and because there's like so much attention on this. There's, everybody wants to know what's going on and what it should be. We'll go ahead and look at it. But really, this should have been clear cut. Like, they're basically saying, you're kind of wasting our time, but we'll take it seriously because, there's so much attention on it. Like, there's so much political heat, basically. Okay. The acts of several colonial assemblies prohibiting purchases from the Indians have also been relied on as proving that, independent of such prohibitions, Indian deeds would be valid. But we think this fact at most equivocal. Let's see what, I think I know what equivocal means, but okay, open to more than one okay. Okay, actually, you know what? I was wrong. I thought I meant something different, to be honest. But we think, okay, so the acts of several colonial assemblies prohibiting purchases from Indians have also been relied on as proving that, independent of such prohibitions, Indian deeds would be valid. But we think that it is open to interpretation. We think differently. Okay. While the existence of such purchases would justify their prohibition, even by colonies which considered Indian deeds as previously invalid, the fact that such acts have been generally passed is strong evidence of the general opinion. Okay. I think I'm picking this. I think I'm picking up what they're putting down. Finally, that such purchases are opposed by the soundest principles of wisdom and national policy. They're saying, like, you know what? Everybody believes that these acts should go into law, and they've been passed, which means that the entire nation agrees, because acts are the actions of politicians that are supposed to be representing people, the general population. So if everybody's saying like this is what it should be, then and nobody's disagreeing with it, then it seems like this is the new national policy. Okay. And if you really think back to the beginning of this case, much longer than an hour ago, they were really only asking one question. And that question was, okay, Britain would say that we own this land and that the Indians have no right to it. What do we believe? That's what this whole insanely long case was about. The whole case was about, well, so what do we believe in, you guys? Like, should we do what Britain taught us, or should we do something different? Like, and it was almost a rhetorical question, because the people who are now citizens of the United States, almost all of them originate from Britain. And so they're going to have a very similar mentality. And this is what I'm talking about, like nature versus nurture. And I'm not saying that, that, for example, that somebody is exactly like their parents, but most often the apple does not fall too far from the freaking tree. In the United States, their apple falls from Britain. So whatever Britain thought is probably very similar to like those people, what they would think. And it's been 200 years now. It's been 200 years since this came into effect. So we have diverged from the mentality of Britain since then. But a lot of our roots in our policy and our law still come from Britain. Like, we inherited their legal system. And and even their, as it mentioned here, I mean, I keep forgetting that they talked about it. I've always talked about, it's funny, I've always talked with people about how closely related religion was with law. And it never it somehow never occurred to me that, well, I wasn't the first one to say that. Maybe I guess I thought I was being original, but nah, not even close. I mean, I'm like 200 years too late. I've But yeah, I mean, you can tell a lot about a nation based on its beliefs, its religious upbringing, and its environment. And the American people were, at that time, most of them were, its voters were from Britain or of some English-speaking descent. And they were the ones who were voting on these laws, and the laws said, hey, um, as far as property is concerned, we believe that we should have this property, and that's what it is. So, yeah. Okay, now that that is over, long gone, give yourself a round of applause. Like, really seriously, that was painful, right? I mean, we're at like 2.5 something hours right now. That's a long case. And so was Marbury versus Madison, and you made it through that too. So, now you've gotten a little sample of one case from each subject, and you'll get an idea of like what they're about. Most of 1L is not going to be this painful. Let me at least say that. Like, the first few cases are absolutely the worst. Once you get past like really like the first 2 weeks or so of law school, you'll start to gain a little bit of understanding. I mean, without any guidance, like what we're doing here, man, like if you have no prior exposure and you have no one to guide you through this, it will take you about a year. It'll take, like a lot of people, it takes them about a year, sometimes 2 years of law school before they start like before it like suddenly clicks in. They're like, oh, that's what I was supposed to do? Why didn't anybody tell me this? So, like I said, you're kind of getting the cheat code here, because you're listening to me go through it, and I already have those that method of thinking and that manner of spotting certain things, right? Like looking up certain words, and I'm like, okay, does this mean something? What does it change here? And I really thought about, because I don't want to rob you of the experience of law school, for example, right? Like I want you to get the full value of being in law school. And what I the assumption that I came up with is that I don't think that this method is going to disrupt that. It's just going to give you a good foundation, honestly, where to go. Because when you hear it enough times, when you watch somebody fish enough times, and they say, "Hey, this is how you put on bait, and this is how you cast," you see it enough times, and you start to pick it up. Now, obviously, it's easier, not easier, excuse me. Some people learn kinetically, so they learn by doing, and some people learn visually. Um, in my personal experience, because I am both a kinetic and a visual learner, um, I do need to like touch and feel and do stuff. So I need to look at cases myself, but it really helps to see somebody else do it first, and do it right, or do it with some experience. I can't even say I did this necessarily right or wrong. This is a really, really complicated case. Like if you made it through this and you feel like you understand everything, you're either a legal instructor, or you're like, I don't know, a freaking legal supermind or something. Like, yeah, go to law school. Yeah. But if you're like me, mortal, you probably have a headache right now, and justifiably so, because this was a lot. You should really feel proud of yourself, like I said, by making it through. So, congratulations for making it through. One one case of each, if each subject that you would see in law school. These will get easier. Let me say that. Like these are some of the worst cases you'll see, because in part because they're so dry. That's part of it. They're super dry. The language is very dense, and the writing is from a different time, and so you have to first, you have to understand it as it is, but second, you have to understand it as it was back then, and then you on like third on top of it have to try to translate it into what it means today. So yeah, not just in language but in significance, and that makes it difficult. Anyway, we are done for today. Thanks for watching. If you have any suggestions for what you would like to see different, maybe you would like a little more explanation, maybe you would like less explanation, maybe you thought I don't know, read too fast or read too slow, let me know. Tell me what your thoughts are. This is a developing process. I am learning just as you are, and I am learning along with you, and you're learning along with me. So, we're classmates in life and in law. Like you never stop learning as a practitioner. That's why you call it a practice, because it never freaking ends. Um, Welcome to the legal industry, I guess. All right. See you all next time. Good luck. And the next time I see you will likely be for torts again. So let's see. All right. Good night and good luck.